Hello and welcome to another edition of Coffee Talk with Attorney Brian D. Lerner. In this particular episode, I'd like to continue a little bit more on testamentary capacity since there is so much on the subject, and that seems to come up with practically every client that comes in the door. I thought I would make it a little clearer on what's needed. Now, a lot of times a client will just come in and say all kinds of stuff. Say, oh, she didn't know what she was doing. She just signed it. She had no idea, and therefore, I want you, the attorney, to go and vacate everything she did. Or you'll get the complete opposite side where it'll go, oh, she knew exactly what she was doing. She understood everything. I don't understand why the other side's fight. Please go to court and make sure everything holds up. Okay, so it's not quite that simple. There's all kinds of other issues, but one issue with testamentary capacity is whether it falls under and the tests you need to do under the Due Process and Competence Determinations Act. Okay, I mean there was literally an act that was passed with laws and regs and all the bells and whistles to determine whether or not, under the law, someone had testamentary capacity in which to do a will or some estate document. And, as I've said in previous videos, just because somebody may have Alzheimer's or dementia or some other mental illness does not by itself mean that they don't have testamentary capacity in regards to the estate. Okay, one thing's for sure, the burden of testamentary capacity as to whether someone has it or doesn't have it is less and is different than if you were to determine it for some other manner, such as driving or job or military service or something like that. Okay, so keep that in mind. It's not the same test depending on the purpose of why you're trying to test whether someone has testamentary capacity. So, the fact is, under the Due Process and Competence Determination Act, is someone can definitely have a mental or physical disorder and still be capable of performing a variety of legal actions regarding the estate, along with their consequences. So, what is it that it looks at? Well, first of all, the Act, and when I say the Act, I'm referring to the Due Process and Competence Determinations Act, but I don't want to say that 32 times during the video, so I'll just refer to it as the Act. Applies to a determination that a person is of unsound and mind or lacks the capacity to make a decision or a certain act if they are doing something that are making medical decisions or executing certain items with wills or trusts. So other than that, the Act does not apply. So it's a relatively limited purpose upon which it was made. Now, what is it that it looks at in order to determine if someone in fact does or doesn't have the testamentary capacity under the Act? Okay, well, first things first, what constitutes lack of capacity? Well, the Act, except where otherwise provided by law, which means there might be some exceptions, but generally speaking, the person lacks the capacity to make a decision unless he or she has the ability to communicate the decision by verbal or other means and to understand and appreciate to the extent relevant. And then there's three things. So first, they have to be able to communicate the decision. Then they have to understand and appreciate these three following things. One, the rights, duties, and responsibilities created or affected by the decision. Okay, so let's just take an example. If they give a house to their child, they have to understand they're giving a house to their child and what that involves. Okay, the probable consequences for the decision maker, and when appropriate, the persons affected by the decision. So this goes on in more detail. Again, if we're talking about let's say she bequeaths a house to her child, what are the consequences of doing that, and how will the person affected by the decision react, or what will happen, and the significant risks, benefits, and reasonable alternatives involved. So there's lots of wiggle room here as to whether or not the person understands or doesn't understand this, but if it can be argued that those items are met, then there's no lack of capacity. If it can be argued that for sure all of those items are not met, then clearly there is a lack of capacity. And then the question becomes, what happens if you can definitely show one or two of them but not all of them? But it makes very clear in here that you need to show or fall under all of them in order for it to apply. So what are the requirements to show this? Well, there's certain evidentiary requirements that you need to show in order to see that someone falls under the act. So, the different categories that it falls under, or that evidentiary packets can fall under, is alertness and attention, information processing, thought processes, and ability to modulate mood and affect. So again, this is a little bit ambiguous as to what falls within each category. However, understand that a deficit in one of those categories, such as alertness and attention, let's just say the person signing it is only alert for 10 minutes a day. Well, obviously that's an issue, but that doesn't by itself mean there's no testamentary capacity. Okay, so the court will look at all this and take into consideration the frequency, severity, and duration of periods of impairment. I mean, frankly, I know a lot of people that clients that I do this for, and usually in the morning after they eat, they're more alert and their processes are more clear than later in the afternoon or during, when they're about to go to take a nap and so forth. So, depending what side you're arguing on will depend upon where you want to show, and that's, of course, what the judge will have to decide. And so, as you can see, there are a lot of different items that you need to look at in order to see if the act applies, and I'll do some more videos continuing on with this because I don't want to do the whole gambit of the act within one video. So as the videos progress, you'll get more subcategories of the act and how to find out what is or isn't testamentary capacity. Okay, if you like the video, click like, subscribe, and also you can call for a free consultation anywhere in the state of California. Okay, more in the coming videos.